Hello, I'm Renee Boston. I am one of the childbirth and medical malpractice attorneys practicing law here at Boston Law Group LLC. Today I want to bring you a little something special, a different type of video. It's still touching on some of the subjects that we deal with when we are talking about birth trauma and medical malpractice cases, but we want to take it a little bit, we're going to take a different spin on it today. Today we're going to go with the next step, or some of the steps that you need to take once your case has been resolved. Now that's from the perspective that we use people like my next special guest for, but she's available for not any specific reasoning, meaning you don't have to have a birth injury case, you don't have to have a medical malpractice case, you don't even have to have a legal case going on. But this person is a special person and a type of person that you need and as a part of your planning for your life, your career. And once you get a career, once you get a job, once you get kids, you need a person like this in your life to help you kind of plan everything out, get everything going. And this person I'm talking about is attorney Elsa W. Smith. She's going to be joining us today of the law offices of Elsa W. Smith here in Maryland. She is an estate planning attorney, and I wanted to bring her in today to talk to you guys a little bit about what exactly is estate planning, why do you need one, what's the goals behind it, and what kind of benefit can you receive from meeting with an estate planning attorney and having your estate planned out from A to Z. So without further ado, I'm going to introduce you to Mrs. Elsa Smith, and she's going to give you a little primer on the basics of what is an estate plan.
Well, good afternoon. It is good afternoon right now, at least on the East Coast. Thank you, Renee, so much for having me as a guest to speak with your audience. As you noted, I am a wills and estate planning, legacy planning attorney. This is what I do, and I've found that now that we're in this COVID-19 environment, it's more important than ever for individuals to take the time and gather the documents that are needed, to think about documents that they don't have. And those are some of the things that I'm going to cover today. So before I get started talking about the specific documents, where I consider some basic estate planning documents that I believe every adult needs, a lot of people don't understand what an estate is. When I'm talking about an estate, when you hear that word, that means everything that you own. That means your cars, your home, your bank accounts, any personal possessions, life insurance policies, 401ks, all of that is under the umbrella of what is known as your estate. And I want to shatter a big myth that I hear very often among people before, of course, before they hire me, is that you need to be rich in order to have an estate. That couldn't be any further from the truth. Any person, any adult needs an estate plan. So what are we talking about? What are some of the basic documents that we're talking about? Many of you who are listening have heard of a will or a last will and testament. There's also a power of attorney and an advance medical directive. Now, the comments that I'm going to share with you are targeted. I'm licensed in the state of Maryland and DC, so these requirements are primarily targeted for a Maryland audience, and you're urged to consult with an attorney that's licensed in your jurisdiction to make sure that you're following all the proper protocols to have your documents executed. So let's talk about a will. Now, in the state of Maryland, there are basic requirements needed to have a validly executed will. The will should be in writing, signed by you, and you're known as the testator. Okay, and it can either be signed by you or it can be signed by someone at your explicit direction, and it needs to be signed by two witnesses. In the state of Maryland, at least for the moment, wills do not need to be notarized. Okay, so why do you need a will? A will does a number of things. One, it is the distribution of your assets and the way that you wish for them to be distributed. That includes personal property. If you want to make specific gifts to loved ones, a will is the perfect place to do that. If there are charities, sororities, fraternities that you want to make gifts, also known as bequest to, the will is a perfect place to do that. Now, for families just starting out, a will is very important because you get to designate guardians for your minor children. And I want to put a thumbnail on here for a second and just pause, because a lot of families don't consider the importance of naming a guardian for their loved ones. I want you to imagine that you, and your spouse, or you're at a cocktail party, at a function, you leave and you get hit by a car. And one or both, let's say both of you are in intensive care, and let's say the worst happens and you both die. Now, my job as an estate planner is to get you to always have a game plan, right? So what happens when you're declared dead and you have little ones at home? Who's going to take care of them? And I want people to start, while we're in this cocooning phase, of our existence right now due to COVID-19, I want you to think about who you'd like those guardians to be. Are those individuals aligned with your values? Because keep in mind, these are the individuals, because you can have more than one, who are responsible for rearing your children. You don't want it left to, family discussions, because that the lack of guidance from you, the lack of preparation from you by not having this in writing, is one of the top causes of chaos among families after one is deceased. Because, think about it. You're gone, you're both gone in my example, and the aunts, the uncles, the grandparents, everybody's fussing and fighting about who's going to take care of your minor children.
And it's everybody on both sides as well.
Absolutely. Absolutely. And who's better suited? And because there's been no guidance, nothing in writing, these children are caught up in a tug of war. And beyond that, you need to think about establishing a trust if you haven't purchased life insurance. And life insurance is another component of a comprehensive estate plan. But and by the way, now that we're talking about life insurance, when you do, you should not ever name a minor child as a beneficiary in a life insurance policy. What the proper thing to do is to name a trust. What is a trust? A trust is just a legal vehicle that you designate in your will to house, if you will, the assets that are for the benefit of someone. In this case, the minor children. So in practical terms, when you purchase your life insurance policy and you're writing down who your beneficiaries are, if the benefit is for the minor children, it would be this particular trust, trust in for the benefit of Johnny and Susie Smith. So that would be the beneficiary as listed on your life insurance policy. Again, you never want to name a minor child. So the other things that you want to consider is making sure that there's sufficient funding in a trust. Since we're talking about a trust, there are different types of trusts. One in particular that's created when you pass away is known as a testamentary trust. And that trust, it's not a separate document, it's part of the will itself. and it can be funded by the proceeds of the life insurance policy. One of the things young parents want to think about also is how that money, first of all, who is going to manage that trust? That's known as a trustee. So this can be, doesn't have to be the same person as what's known as the personal representative, the person that's going to distribute all the assets named in your will, or in your estate, I should say. The trustee of this trust can be a separate individual. This individual is only tasked with managing the funds, the assets that are in that estate. Now, following my example, if we have two little ones and the trust created is for their benefit, you'd want an individual that's specifically tasked with making sure that those funds are used for the benefit of these minor children, for their education, if they're in private school, any classes, sports activities. Just think about all the things that you'd want to spend money on for your minor children. The trust would be the proper vehicle to make sure that that funding is available for the minor children. A great thing that a trust also does is that you could specify the distribution of money for the benefit of the children at different intervals. And you create the trust with the parameters that you like. Again, the trustee is a fiduciary, and that means that a person that's acting in your best interest, in this case in the best interest of the children. So be very mindful of who you select as the trustee for your trust. Going back to a will to the will in general for a second. Some young families think that, well, I don't really have assets, so I don't need a will. And or here's something else that I hear most often: the wife in the married couple is saying, well, my husband will take care of it. No, newsflash: each of you needs a will, because each of you have an estate. Even though the assets may be jointly owned, it is very important for each of you to have a will, for a number of reasons. But just so that if say if your husband dies before you do as the spouse, if he doesn't have a will, he dies in what's known as an intestate status. That means that the state, in this case the state of Maryland, will decide how his assets are to be distributed, because there is no will, right? So, and we don't ever want that to happen. The reason that we want people to think about and then ultimately create an estate plan is to put you in control, to make sure that your wishes are fulfilled, and your legacy planning is executed as you wish. Not sure if you have any questions about wills that you wanted answered, but those are definitely the basics. Again, signed by the testator. You need two witnesses, and it doesn't need to be notarized. And I would highly advise you to seek the advice of a professional with crafting a will, to make sure that everything that you want is included. Oh, one other thing: a will, just like many estate planning documents, is not a one and done. And I was going to touch on this point towards the end of the presentation, but I want to just underscore this point now. A will can be amended, right? And in my world, an amendment, it's also known as a codicil. If there's a minor amendment that's needed to a will, it can be amended. And many of them usually are, because your life situation changes, your family dynamics change. So a will is not a one and done, as are any estate planning documents. The next important document that, especially now, I believe every adult should have, is known as an advanced medical directive. And in the state of Maryland, an advanced medical directive has two parts. The first part is where you name your health care agent or health care power of attorney. And this individual is, as the name implies, that is the person that steps in your shoes. This is the person that speaks to the doctors on your behalf, and makes medical decisions in your favor. So again, you want to make sure that this person is competent, responsible. I always advise individuals that the person that you name as your healthcare agent not be an individual who is a beneficiary on your will, in your will.
And
And if it's not obvious,
the potential conflict with that.
absolutely, absolutely. You don't want the individual that stands to, inherit millions from you to be the person that decides whether the plug is pulled and when. So that's the conflict of interest my colleague Renee is referring to. If that didn't jump out at you immediately. So you really want that to be another individual. Now, the second part of the advanced directive is known as what's called the living will, right? And in that section, you're provided three different end of life or end stage scenarios. And in each of those scenarios, you have the option. And I say option because this part is not required for you to complete, but you can indicate whether, whether and to what degree of intervention you want. Do you want them to pull the doctors to pull out all the stops, or do you want to just die or pass away peaceably? You also have a section where you can state what your life philosophy is, how you've lived your life, and whether there's some people, for example, who have lived a very full life, and they say that no matter what happens, I just want to, die peaceably, and with my children around me. That's a simple statement. Again, not required. Part 2 is completely optional. I highly advise you to at least have the conversations now about that, because it's very important. The time to make these decisions is not when you're in crisis. And as an estate planning attorney, I beat that drum all the time, because the time to make the decision is not when they're wheeling you into the ICU, right? It's not when somebody has is at the point of death, they're in a car crash. It is times like these, when we're all required to be at home, we're with our families, our loved ones, and for better, for worse, we are required to stop, breathe, and think about what, how do we want our lives to be on the other side of this? Because I'm a person of faith. I believe that we will all get through this. And my challenge to everyone that I have the pleasure of speaking with is like, what's the game plan when we're all on the other side of this? Are you going to be more informed or empowered? Are you going to take advantage of the time this precious time that we have now to think about our families, what they need? And estate planning is not just about, the hereafter. It's about your quality of life right now. And that's where the advanced medical directive comes in. It's having an individual who is going to advocate on your behalf. And you're also, part 2 is also giving guidance, not only to the healthcare agent, but it's a statement to your loved ones as to the type of care that you want. Keep in mind, put yourself in the place of the people that are outside in the waiting area, in the waiting room. in the emergency department while the doors are locked or doors are closed and you have no idea what's going on. They're in anguish, quite frankly. And without a document giving guidance as to what you want to happen, so they're going to, one or more individuals are going to be tasked with the responsibility of, making a decision regarding your welfare. And if they don't even have, if they have nothing, no guidance, nothing in writing from you, that's just going to add to the anguish that they already feel, maybe the guilt of possibly making a wrong decision. So that's why it's so important. Typically in families, and it doesn't matter, race, social, economic status, we see a lot of the same issues happening in families. Nobody wants to talk about death. Nobody wants to talk about, what's going to happen to all of us. We're all going to die. We're all going to pay taxes. And at some point, we're all going to get sick. It all depends on the varying degrees of sickness. And one of the barriers that I find that barriers to starting an estate plan is fear. And that's pretty well documented. It's fear of death, fear of making a wrong decision, and fear of having those what I call the uncomfortable conversations with family members, or making uncomfortable decisions. Here's what I mean. Say you have, say you have 3 children, and each child is unique with their own skill sets. And some children may be more responsible than others, right? So you've got to choose one person that's going to be what's known as your personal representative if we're talking about a will, right? And if we're talking, it's sometimes you just, if there's one child that's kind of flighty, not really responsible, kind of like a gypsy, that may not be the right person to choose as your
person. In addition to what you said about being uncomfortable conversations, we also need to have honest conversations too, because I think with a little honesty and also self-reflection, you can pinpoint who would be best suited for whatever position you need in your estate planning throughout whether it's the medical stuff or the guardianship stuff or personal representative or anything in between.
Oh, you know what, Renee, you just brought up something else, since we're talking about minor children, and that's, I know that's, we want to speak to young families, at least in this session. The guardian that you ultimately choose does not have to be a family member. Okay, because something else that nobody likes to talk about, but at least in confidence in my office, I have people tell me, Attorney Smith, actually, I don't trust a whole lot of people in my family to raise my children. However, I do have a lifelong best friend who's been with me through thick and thin, very responsible, good job, yada, yada, yada. And I trust that person more than I do some of my family members. And you know what? That's okay. Why? Because it is your estate plan. It is not your siblings' estate plan. It's not your parents' estate plan. It's yours. Okay. And if you have minor children, you and or your spouse have the ultimate say as to how those children are to be cared for, what provisions are made for those children, the environment that you want those children to grow up in. Now that's getting more into legacy planning, right? What is the future that you want to create for your minor children? The documents are one aspect, that's estate planning, and yes, we do that, and we do that regularly. But the conversations that I, beyond that I like to engage with with my clients is, what's your larger picture? Are there causes the Cancer Society, other societies that mean something to you, that have benefited you in some way, that you want to leave something to. That's charitable giving. That's a part of estate planning. The church or place of worship that you belong to, if you'd like to make a gift to them, that's also part of charitable giving. But I wanted to go back and touch on the guardianship point, because a lot of young parents, they may not feel comfortable with people in their own family, and I tell them, do you have a best friend? Do you have someone that the children are comfortable with? And they go, you know what, actually there is. And then you start the conversation. I said, but I didn't think that we could. Yeah, you can.
Well, let me ask you this, to piggyback off of that.
Mm-hmm.
Do you think it's a good idea? Because I was watching, I think a rerun of Grey's Anatomy or something during our shut-in time.
Yeah.
And someone was named a personal representative, and they had no knowledge that they had been named to that role. Do you recommend or should people have conversations beforehand as to, I'm putting together my estate plan, and I want you to play X, Y, and Z role in my estate? Should they have that conversation with this person beforehand, before they start gathering things, or can they go to you first, do everything, and then say, okay, I'm going to name, my cousin twice removed as, my guardian for my children, without having really cleared it with the guardian first?
If they do, and that has happened, I usually kind of put a pause and say, you know what, you might want to talk to this individual, because even though you think that the person might be okay with it, a lot of people may be intimidated by what it means to be a personal representative. Oh, I've never done this before, and I've got to manage assets, and I'm also grieving, going to be grieving your loss, and I don't think I want that responsibility. So yes, absolutely, just as a form of respect, just ask. And most people are usually honored that you are entrusting them with this responsibility. In part, and to talk about what some of those responsibilities are. As I said at the beginning of my presentation, a personal representative is tasked with making sure that your estate, everything in your estate, is distributed according to your wishes. And if it's necessary for there to be a judicial determination, that's called probate. If your will needs to go before a judge because there's things that just have to, there's property that's owned, depending on the nature of the ownership of property, it may have to go through a court process known as probate. And during that process, yes, there are lawyers, there are other professionals involved, but the personal representative doesn't have to wear all those hats. One of the benefits of, and what's permitted as, an administrative expense when probating or making that judicial distribution, I guess, of an estate, is that the personal representative can consult with accountants, with realtors, with financial advisors. These are all acceptable and reimbursable expenses when it comes to administering estates. So a personal representative doesn't have to wear all these hats. So whoever you choose just needs to be a competent individual, a trustworthy individual, and working with a licensed estate planning professional in your state. They're going to help guide the personal representative through the process, so they're not in it alone. Before I forget, the last document, a very important document that I believe that every adult should have, including those who have young families, is a power of attorney. We talked earlier that in the Advanced Medical Directive, the Part 1 is a healthcare power of attorney. The power of attorney I'm referring to now is a financial power of attorney. It's known as a financial power of attorney, and as the name implies, it's to put someone in your place to manage finances. If you want that individual to handle your banking, if you become incapacitated, if you want the individual to manage your real estate affairs, buy, sell stock, open accounts, close accounts, you can give an individual that that power. Now, unlike a will and an advance directive, the power of attorney must be notarized. Okay, and again, it's critically important that you select someone who is trustworthy, that you feel comfortable with, because in many cases, unless there's a specific provision in the power of attorney indicating otherwise, once you name a power of attorney, it's effective immediately. What does that mean? The person can walk into a bank and drain out your accounts. Why? Because you have given them that power. As that person stands in your shoes and walks into the bank and has the power to do so because they have that document that you have signed, naming them as your power of attorney. As I said, it needs to be notarized. Now, we are doing this session in the COVID-19 pandemic, and at least for Marylanders, Governor Hogan recently signed an executive order which waives the in-person requirement for documents to be notarized. Now, there are specific requirements that the notary has to follow in order for the notarization to be valid in Maryland. So just make sure that you're working with a competent attorney, and that can guide you through that to make sure that all your documents are properly executed. Let's see.
Well, let me ask you this.
Sure.
So, some people, I don't want to say any names of the different companies, but there are companies that you can Google and they, I'm looking for this specific form or that specific form. Or what are your thoughts on people, I guess, downloading their own forms from these websites and creating, I guess, a makeshift estate plan through these forms without actually talking to an attorney or talking to pretty much, like you said, a competent, a licensed estate planning person?
Well, I always advised against it. Yes, they're available, and what we do, at my firm, it's more than just generating documents, because what happens is people will come to me with documents that they've printed out online, or that their barber gave them or whatever, and then I look through them, I go, well, this is missing, and what about this? So they're going to end up paying more on the tail end to have me really redo, because I'm not going to correct something that you've brought to me, that you've downloaded, online. Just for liability reasons, I just won't do it. So don't be, what's the saying, penny wise and pound foolish.
Right.
Invest in yourself, in your family, by sitting down with professionals, like Renee, like myself, when it comes to estate planning, so that you're starting off on the right foot. The other reason why you want to consult with an attorney is that, at least in my firm, we pride ourselves in developing a relationship with our clients. What does that mean? So once you leave our office with a nice binder with all of your documents properly executed, you probably won't hear from me for maybe a couple years, and I'll give you a call and go, hi, Renee, how's the family? This is Elsa. Just want to know how things are going. Like, oh, okay, so you purchased a new property. Oh, or there's a new child in the picture. We may need to revisit your estate plan, because now you have someone else. If we're talking about a new child, a new beneficiary, somebody else that stands to benefit from your estate. That what that also means is that we need to look at your life insurance designations. Is that child included? If we've created a trust, as we've talked about earlier, you know, for let's say the first two children in my hypothetical, have we made provisions for the third child? So all that's what I mean, that it grows and and we adapt it as your life changes. You know, the estate plan for a 20 or 30 some young family is going to be significantly different in most cases than the estate plan of folks that are in the maybe 60s or 70s, ready to retire in retirement with adult children. So the beauty of working with an estate planning professional is that we can modify. We don't necessarily need to rewrite everything, but we modify your estate plan as your family dynamics change. And that's something that you can't get from a website.
Right.
Mm-hmm.
Well, actually, that's all the questions I had for you today, Attorney Smith. Do you have any tips or any kind of tidbits or helpful hints that you want to leave the viewers with at this time?
I do. For all of the individuals who are watching this video, I want to offer my free 21-point estate planning checklist. And we can provide the information underneath the video, but it's completely free, and while we're all cocooning, it'll put you in the mindset of, okay, these are the documents that I need to have in place. And by the way, our office, it's the law offices of Elsa W. Smith, we are doing virtual consultations. They're safe, they're confidential, and they're convenient. So you and I can talk just as Renee and I are talking right now via video. But going back to the checklist, it's pretty extensive. And if you haven't thought about certain documents that you need, this checklist will bring to mind documents that you may want to get to, start, putting in place. So I'd be happy to offer that to your viewers, Renee.
All right, thank you very much. We greatly appreciate that.
And I want to thank you for the opportunity again, for being a guest and to be able to speak with your viewers. It's been a real pleasure. Thank you so much.
Thank you so much, Attorney Elsa W. Smith. We will be providing Attorney Smith's contact information in the video, as well as I think we're going to put a link on our website, our YouTube channel, as well as social media, and we'll provide you links to her contact information as well as a link to the 21-point estate planning package that she has. So I want to thank you all very much. Again, thank you very, 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 very much, Attorney Elsa Smith. We greatly appreciate it. And that is going to be all today from Boston Law Group, LLC. Again, I am Attorney Renee Boston. I am one of the childbirth and medical malpractice attorneys practicing here at Boston Law Group, LLC. Thank you for watching, and we'll see you next time. Take care.